this whole case is about. Viles found her credit, and then later she changed her mind well after the transaction occurred, and she changed her mind based on something that had nothing to do with financing. When Viles tried to collect the money from her, she countersued, and that resulted in a jury verdict, and we are here today to challenge that verdict. There's three primary bases that we contest the verdict. The first is, it's our contention that the relevant contract was incorrectly interpreted. The other is that Ms. Chance has not proven all of her damages that were awarded. And third, we believe the Tennessee Consumer Protection Act claim was flawed. On the interpretation issue, the contract squarely identified what was needed, and it said get a credit approval within 3 days. That is now being interpreted as a final approval, but it doesn't say that. It just says a credit approval. The only document from those 3 days is a document that said credit was approved. 9 days later, that's 6 days after the deadline, the financing company reversed its decision and took away that approval. My client didn't even learn of that withdrawal until well after the 3-day period. The contract is also being interpreted to make actual funding, receipt of money from a bank, a requirement. That does not appear anywhere in the contract documents. Now, I would add again that these financing issues are not why Ms. Chance tried to get out of the transaction. She brought that truck back on October 19th, and I would refer to the trial transcript, pages 181 and 182. That's 19 days later, not within the 3 days. It wasn't, oh, you didn't get the financing, today's day 4, I want out. It was 19 days later.
Excuse me for interrupting,
Yes.
counsel. You referenced the verdict earlier. Did the jury determine breach of contract or conversion in this case?
My recollection is that, and I'll defer to Ms. Chance's counsel, that both were on the verdict form. No?
In looking at the verdict form, I believe it provides in paragraph number 1, if the jury finds the contract between buyer and dealership was not enforceable, is the dealership liable to the buyer for breach of contract or conversion? And the answer was yes. So the verdict does not identify whether it was breach of contract or conversion. Is that correct?
That's my understanding.
And did the jury make a determination that the contract was not enforceable?
Well, based on what you just read, it would appear so.
Am I reading correctly from the verdict form? That's the one that I found in the record.
If you're reading from it from the record, that's what it says.
Thank you.
Okay. So moving on, that conversion claim, just to sidetrack my argument, dealt with the sale of the trade-in vehicle. And if the contract interpretation is right, the contract was valid, my client would have had a right to sell that vehicle. Moving to damages. The jury awarded $1,157 for breach of contract and $60,000 for the Tennessee Consumer Protection Act claim. And it strikes us that those numbers should have been the same because you can recover the same damages under each, but they're not the same. So when we look at the $60,000 and we take away the $1,157 for breach of contract, that means she received $58,843 in intangible soft damages. It's our contention there was insufficient evidence. Granted, you have to take the evidence the way it's developed at trial. You have to give deference to it, but you don't have to abandon your common sense. Let's look through this. There's two bases for the damages that Ms. Chance puts in her response brief, and that's on pages 32 to 34. The first one is that it hurt her credit. Well, her credit was already bad. That was her testimony. Plus, this financing didn't go on her credit. What happened to her credit is that a credit inquiry was made. She gave conflicting testimony on how long it was there. The minimum was for a few days. You do not have to take your common sense and throw it out the window to say she suffered $58,843 because a credit inquiry was on her credit for a few days. The other category of damages was lack of use of a car. Now again, she already testified that her credit was already bad and she needed the help of her mother or her husband as a co-signer to get a car. And of course, she never testified that they would not help her. So I looked at the rental receipt. It's Exhibit 11. It says that she paid $656.08 for a 12-day rental. That's $54.67 a day, which I think is excessive, but what I think doesn't matter. It's $54.67 a day. So we take $58,843 at $54.67. The jury would have awarded her rental expenses for 1,076 days. That's 35.9 months, 3 years. She couldn't get a car in 3 years with the help of her mother and her husband. Clearly, these damages were the result of passion. They're speculative damages. Now, when we get to the issue of passion, that brings us to the Tennessee Consumer Protection Act claim. The jury was given an inapplicable car dealer statute and repeatedly told that Biles violated it. That's TCA 55-17-114. That statute is only applicable to transactions conditioned on a receipt of funding, and that's a quote, funding. There is nothing in these contract documents that say funding was needed. That statute was just completely inapplicable. But it went to the jury, and they were told Biles violated it. And then the jury awards $58,000 for a credit report where the inquiry was a few days and rental car expenses that would have covered her for 3 years. Also, the sections of the Consumer Protection Act that the appellee sued under, sections B2 and B12, those are all based in financing. And again, financing's not an issue. The issue is, was there credit approval? And in those 3 days, the only document that exists in that period says it was approved. The Consumer Protection Act claim is just not applicable to this case. So with that, I have a minute and 25 seconds. I'm happy to answer any questions you have, or we can get to tea time early.
Well, I hear no questions.
Okay, thank you, Your Honor.
Thank you. You have your time for rebuttal. Hear from the appellee.
Thank you. May it please the court, Marshall Stair with Lewis Thomason on behalf of the buyer, Miss Chance. So I think it's important to take the big picture look of what this transaction is all about, and that is a transaction for a vehicle that's contingent upon third-party financing. These deals happen all the time across this state and across this country. And what happens is a buyer goes into a dealership, they pick out a vehicle, they run some preliminary credit on them, they work out a deal. But the deal is contingent upon a third party financing the deal. And what does that mean? That means the bank or lending institution pays the dealership, and then the buyer pays the financing company over months. It's very common. But what happens in these transactions is buyers go in, they sign all that paperwork. If you've ever bought a vehicle, they go home, and sometimes financing is rejected. And the reason why dealerships, like the dealership here, put these clauses in the contract is because they want the right they want the right to repossess or have the buyer bring that vehicle back in case the financing is not approved. And that's what's happened here. The little twist is, it is actually the buyer relying on the dealership's contract to void this deal.
Excuse me for interrupting,
Sure.
counsel. Did the jury find a breach of contract or conversion?
I mean, I think, you know, the jury form will have to speak for itself. I know he has contested that in terms of the damages. The jury verdict form was agreed to by both sides prior to the trial. So I think any objection to that is any objection to this court is moot. It was approved by both sides. It was approved by the court, and that's what the jury relied upon.
And did the jury make a determination that the contract was not enforceable?
Presumably so, because they found for our client. This whole lawsuit started when the dealership sued my client. My client was forced to file an answer and also filed a counterclaim. After years of litigation, on the eve of trial, they dismissed the claims against my client. So the only thing that went to trial were my client's claims against the dealership, and they found for my client. So I think obviously they found, just like the denial of summary judgment, that the deal was null and void. And if you look at Exhibit 3 from the trial exhibit, that's the key exhibit. That's the key.
Is it your client's position that this contract was not enforceable?
Not enforceable, correct. Yes, the contract states, the seller and buyer intend that the seller assign this contract. In the event the seller is unable to assign this contract, parentheses, get credit approval, in parentheses, within 3 business days thereof, the contract shall be null and void, and the buyer either has to pay cash or return the vehicle. And this is a bailment agreement. It's Exhibit 3. So this whole argument that credit was approved, let's think about that. That makes no sense. Okay, the credit approval process, when you go to get credit card or a loan, or in this case have a third-party financing institution fund a vehicle, what happens? It's a process. They look at your credit. They look at your job. How many times have you moved? All this information. If it's actually approved, they fund the deal. They extend you credit. That never happened here. So while the dealership's whole argument was credit was approved is complete nonsense, because credit was never approved. And the reason why we know that is Trial Exhibit 6 is a letter from 2019 from the dealership, from counsel, states, the first financing institution declined to extend you credit. That was their position in 2019. But this whole time, and you'll see it in their briefs, I mean, it's the headline. The contract required credit approval. It was never approved. So whether you look at whether the words assign, whether it's financing, whether it's funding, whether it's credit approval, it all means the same thing. And what does that mean? It means a third-party institution, financing company, trusts the buyer enough to fund the deal and then get paid back over time from the buyer. That never happened here. It's undisputed that that never happened. So there's been all this focus on credit approval, and yes, there is a document the day she went and signed that does say approved. It's Exhibit 12, but it has stipulations. It's Trial Exhibit 12. It does say approved. It was from the same day she signed it, but it has stipulations. Those stipulations didn't work out. Funding fell through. It was never approved. If you can imagine if the shoe were on the other foot, there is no way a court would enforce this deal. I mean, can you imagine if the dealership said, you've got to bring the car back, the funding didn't come through. You know, it was eventually, for whatever reason, your credit was not approved. And they said, no, I was pre-approved. You know, I've got this document here. Well, we never got funding. What's important both to the buyer and the dealership is that the third party is willing to fund the deal. That's what's important. That is the heart of a third party financing contract, or a contract contingent upon third party. Is a third party willing to fund the deal? That never occurred here. So yes, I mean, one of the questions that was asked in the appellant's brief was, did credit approval require actual funding? Yes. That is the only logical outcome. Why would they have it in the contract that she get pre-approved but not fully approved? There's no benefit to either party for that to be in there. Furthermore, if you look at the document, the title of it is bailment agreement. We know what a bailment agreement is. It's an agreement between two parties where one takes possession of property that's the other's. In this case, the vehicle maintains its ownership with the dealership until the financing goes through. That never happened here. Normally, you can still undo it, but what happened here was the dealership sold her trade-in vehicle. So they could not get out of this deal. So that's why they sent her this letter saying you either need to pay cash or find alternative financing, and that's what started this whole dispute. So I hope that covers the issue on the contract. The Tennessee Consumer Protection Act is definitely applicable. The argument that it didn't require funding makes no sense. Of course it required funding. That's what third-party financing is all about. I mean, imagine buying a house that's contingent upon financing. Well, just because you have a letter from the bank, if the bank's not willing to fund the deal, the deal's off. That's what we have here. So the TCPA certainly applies. And he argues that the TCA doesn't apply because it excludes credit terms. There's no dispute here about credit terms, about interest rates or month or term. This is about misrepresentations of the legal obligations of the parties. And that is a violation of the Tennessee Consumer Protection Act 104B12. And that was the jury instruction that went to the jury, and that's what they found that the dealership violated. The jury, 12 members of Knox County found that. The judge who listened to the evidence agreed and doubled the damages for the behavior of the dealership.
Counsel, if you would, I want you to address opposing counsel's position as to the $60,000, the damages.
Sure.
Was
In
the
terms
amount
of
appropriate?
damages, first is the standard for this court is the material evidence standard. Courts have said very deferential to the award by the jury. This is what the jury heard. And to live without a vehicle is very difficult, and the reason why she didn't have a vehicle is because the dealership sold her vehicle. How can they come in here and say she should have a vehicle when they illegally sold it? They sold it before they had received the funding, which is a direct violation of 55-17-114. I think that the jury found that was very difficult. She testified how she had to borrow cars and felt ashamed that she didn't have a vehicle. When she walked into this transaction, she had a vehicle. And when she came out, she didn't. And she didn't have one at the time of trial, which wasn't until the fall of 2022. The purview of damages is in the jury. And the chancellor who heard all of the evidence didn't reduce it. He actually awarded double damages based on the flagrant illegal actions of the dealership. And the decision by the trial court to double the damages from Blosser v. Johnson should only be disturbed if there's no evidence to support the trial court's decision. I think if you look at the trial court's decision, and there's two different chancellors throughout this process. The first chancellor's decision to deny the motion for summary judgment, they were the same issues that were litigated in front of for the trial. The documents are the same and were basically stipulated by both sides before trial. And then the court's memorandum opinion. And we feel the trial happened in, I think the verdict came down early November 2022. There was a violation of the TCPA, so we knew there was going to be a request for attorney fees and to treble the damages. We filed that motion. It was, I can't remember when it was heard, but the court issued a memorandum and opinion February 3rd, 2023. We wait 30 days, nothing happens. It awards double damages, it awards attorney fees, it has a number at the end. It is clear, it resolves all the issues between the parties. Nothing happens for 30 days. We file post-judgment discovery, and then the dealership filed a motion for a final judgment, even though one had already been entered. We think this whole appeal is not timely based upon that final judgment on February 3rd. Now, I wish it was titled Final Judgment. Instead, it was titled Memorandum and Opinion. But I think if you read the rule, it's very clear. It's not the name that matters. It's what it is. And it was clear. It was an order of the court, and it resolved all issues between the parties.
As I understand, the trial court considered a motion with regard to the entry of a final judgment, granted that motion, and then directed that a final judgment be entered thereafter. Is that correct?
That is correct. But the court also stated during argument, and it was put into the order, the court intended that the February 3 memorandum opinion be the final judgment. I think for safety or what have you, they allowed for another entry of a final judgment, but you'll see it's basically the same thing that happened on February 3rd. So this appeal is not timely. The statute, again, it's directly on point. The statute was passed by our state legislature to stop exactly what happened here. When a deal doesn't go through, but the dealership already sells the trade-in vehicle. That's the entire purpose. This statute, it couldn't be, it's to prevent the exact factual scenario in this case. And the Tennessee Consumer, the TCPA, it's about, B12 is about the rights and obligations of the parties under law. This statute had to be presented to the jury so they knew what the law was. So they knew what the law that the dealership had to follow. So I see my time is ticking down. I think the trial exhibits speak for themselves. This is a very clear case. The dealership drafted these documents. Financing was not obtained within 3 days. And the deal was null and void, but because they had violated the statute, they couldn't undo it, tried to force her in, and created this situation. And we're here today, and it's May of 2024.
Thank you.
Anything else?
Hear from the appellant rebuttal. Counsel, let me ask you a question here. Was the contract assigned within 3 business days?
Using the word, the way it's defined in the document, yes, because it's defined as get credit approval.
Excuse me, what it says is, in the event the seller is unable to assign this contract, parens, get a credit approval, close parens, within 3 business days, contract is null and void. Was the contract assigned within 3 business days? I mean, that's what it says.
According to our definition of, as lawyers of assigned, no. The way it's defined in that contract, yes, it's specifically defined. We don't need to interpret the word. It is specifically defined. I don't think we as lawyers or judges can substitute our belief of what the word assigned means for the explicit words in the contract.
Okay.
But again, that's your decision, not mine. We also heard that she was relying on the dealer with respect to this financing issue. She relied on nothing. She did not change her mind because of financing. He also said it's contingent on third-party financing, and he argues, he, meaning Mr. Stair, who I would add has done an excellent job in this case. I give credit where credit is due. He argues what it usually is. This isn't a case about what it usually is. What's relevant is the way it was done in this case. We go back to that definition of assignment. Not the way I would have drafted it, but that's the way it was drafted.
Excuse me for
Yes.
interrupting, Counsel. Could you address whether the notice of appeal was timely filed?
Yes, Your Honor. Okay. Rule 56 requires a judgment or a final order. I cited 18 cases for the proposition that a memorandum opinion is simply not a judgment or a final order. I mean, the case law is crystal clear. Cases say a memorandum opinion is not a judgment. Cases say it can't be a judgment if the judge doesn't incorporate the memorandum opinion, or the memorandum opinion does not itself say it's a judgment. None of those things happen. It's a memorandum opinion. We can take our opinion that it resolved all issues, which it didn't. As I argued to the trial court, she was still seeking prejudgment interest. That wasn't resolved. But we go by the title of the document, and it no way said it was a judgment or a final order. And then you also touched on this too, Your Honor. I filed a motion for entry of a final judgment. The Chancellor granted the motion. What he intended means nothing. We have no transcript to put it in context. We're getting the recollection of one of the parties' counsel. So what he intended means nothing, because clearly he changed his mind, or he wouldn't have granted the motion. And that brings us back to the rule we all know so well. A court speaks through its written orders. That's how we get rid of the confusion and the potential for these kind of disputes. His written order is crystal clear. So I believe the appeal was timely filed. The notice of appeal was filed within 30 days of the final judgment being entered. Going back to the argument, Your Honor, on damages, yes, you have to take the material evidence. Yes, you have to be deferential to the jury. The problem here is speculative evidence isn't evidence. It's not material evidence. This was speculative evidence. If you look at Exhibit 2, her payments were supposed to be $545 a day. Even if she just saved her money for 10 months, she would have had $5,400. So in that 10 months, she would have paid $54 for rental cars. There's no way it was 36 months, 3 years. The jury had to have made its decision based on passion. The number is, respectfully, it's just too high. It defies common sense, and the court does not have to take that. I'm happy to answer any more questions you may have.
I hear none.
And let me say this to Your Honor. I needed several extensions, and I just want to say I appreciate the court granting that. That helped me a great deal. Thank you.
Our thanks to counsel for both sides. We appreciate your argument and your briefs on this. Call the next case, please.